listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law with Kyla Lee. Obviously, I am not Kyla Lee. Kyla is not available today because she's in court running a trial and the week caught up on her. So this is Paul Doroshenko, and with me today is Alice and Alison.
Hello. Both of us are also not Kyla.
Both not Kyla, but both articled students with our firm. And Alice has been with us for a long time because she worked as a summer student, and you are now months into your articling, I guess. I don't know how long, but Alice knows everything. Alison has been with us for how long? A little while now.
Month and a half.
Month and a half. Yeah, you've had the fast curve of the immersion into. Yes, and so lots to learn, but you seem to be picking it up very quickly. And I can tell you that you're picking it up very quickly because there has not been a single complaint about you.
Oh, I love to.
So Alice and Alison are two of the stars in the firm. So because we don't have Kyla, we thought we would do it a little bit differently this week. We would do it on video. If you're just listening to the audio might not be so good because we are in my 1953 Buick Special, which I don't drive very often. It has been parked for 2 years because I couldn't figure out what the problem was with it. And the problem was a fuel pump. And ChatGPT resolved my fuel pump issue for me, told me how to fix it and what was wrong, which was fascinating to me. And I learned this week that another lawyer got in trouble or is in trouble for using AI.
Of course. Another one?
Are either of you using any AI for the work that you're doing at this point?
No.
No?
I'm scared of it.
You don't be too scared. We're going to have an AI discussion because you just really need to know the limits of it and how you can use it. I found it, for me, it's been very useful in some things, but I don't use it for legal research, right? And I don't use it for legal writing. And that seems to be where people are getting in trouble with it. It's not going away. So it's the type of thing that, you have to learn how to use. But we're not talking about AI this week. We actually have a lot to talk about. But Kyla had posed 3 questions for me to ask you guys before we get into our discussion. And of course, I don't have the 3 questions here in front of me because So maybe you can read the questions and we'll go from there and then answer them.
This is such a student thing to be over prepared.
Oh, so
Yes.
we drove to find a shady spot. That was exciting. In the 53 Buick, the car behind us is like an old Dodge van. You won't see that in the rest of Canada because there's none that are still surviving. But in Vancouver, there are such things. So, Alice, let's go with question 1.
All right. Question 1. What is the biggest thing you've learned about driving law since working for us?
Okay.
I think the biggest thing that I learned about was the RP scheme generally. I didn't know about it at all. I knew, you shouldn't drive impaired. But that was it. I didn't know any of the consequences. I'm sure most people generally also don't know about the consequences. The IRP scheme is very mysterious in many ways, much like the rest of law. It can feel very inaccessible. So I feel like it took me getting into the firm and learning about what you and Kyla do to really understand this major aspect of driving law in BC.
Yeah, that's a good point. I do TikToks about it every once in a while, and sometimes I think it's just too complex for me to explain in a TikTok because there's all of these contradictory things, and we're going to discuss one of those today in this case that we've got. It's not something that's taught in law school. Probably good reason for that. It's something I feel generally that the government has spent no time explaining to people in reminding them. So when the law came out, they were fairly clear about it. They said how it worked, laid it out a little bit, and wasn't accurate the way they said it, but it was public education. And there's been no public education since. And people just, some lawyers and police officers got angry at us for referring to it as a DUI. And it's just like, it's so complex for people. Why make it difficult when you're trying to describe it? But yeah, for sure. All right.
Yeah,
Alison.
for me, kind of similar, but if I were to go into it a bit deeper, I had no idea the complexities and the nuances of the actual breathalyzer test, and what can alter it, and that forming the defense in law. So things like the keto diet or intermittent fasting or types of medications you're on, even the type of yogurt you have. And if that's within a few minutes of you getting pulled over and doing the test, that can impact your results. And that is something that I did not have any knowledge of before. And I don't think a lot of people on the road
Yeah,
do.
I think you're absolutely right. Yeah, I mean, there's so many different angles to breath testing. I was just reading a journal article written by Wayne Jones, who's the leading expert who's still alive in absorption elimination, breath testing, and everything. Nice guy. Met him at a conference, and I actually had him write some expert reports for me at some point. He worked for the Swedish government for decades, and then he became a professor at the end. And he's still writing, although he's in retirement. But he was doing a survey of some of the literature and talking about some of the issues behind it. And one of the things that still shocks me to this day, is that the partition ratio, so the breath to blood ratio, that the breathalyzers operate on is 2100 to 1. So 2.1 liters of breath to 1 cubic centimeter of blood. Yet that breath to blood ratio has never been properly researched testing women, testing people who are not in Europe. So most of that testing comes from either the 1950s and 60s in Canada and the US. Who were they testing? They were testing men at nighttime. They were giving them immunity from prosecution, provided they could draw their blood and take a breath test. And the rest of the testing was done in Sweden and Germany. Well, gee, kind of monocultures, testing mostly men. And so, the science is racially biased and gender biased.
Add that to the list.
Of all of those things. Yeah, it is. It's a fascinating thing. How are we doing with our recording? Looks like we're doing okay. Here in the Buick. Driving law. We should have driving law podcast, should be done in the car every once in a while. So what's the next question that we've got?
The next question is, what surprised you most about driving law since you started this job?
Okay, well, that was kind of half covered in that first question, wasn't it?
I mean, I could talk about it more.
Sure.
And this will flow on into the case we talk about later, is the intersection of
Charter rights with driving law.
Yes. I will tell you, there's one thing that always gets me with that. When you are pulled over and the police are using an approved screening device in Canada, in the criminal context, there is use immunity of all of that because you have not been notified properly of your 10A rights. I need a truck just like that for the distillery. So every time there's a deck truck drives by, I'm always looking at it. So as you know, you have use immunity for the reading, for the discussion beforehand, for the admissions that you make, because you have no 10B right, and your 10A right is sort of vaguely given to you. And so your right to counsel has not been given to you. But in the IRP context, they take those things for which you would normally have use immunity. They don't notify you that you don't have use immunity, and then they use it against you. And so, it feels like a trap, like it feels like a trick to deceive people. And that one gets me. But that's the intersection of charter rights this feed into that case we're going to discuss. But yeah, that is a good point. Question again, so Alison can answer it if she wishes to.
Yeah. What surprised you most about driving law since you started this job?
Yeah, I think it does kind of go into what we're going to discuss in the case and what we discussed previously. But a lot of it is just no one really understanding their rights. And like you said, they weren't really read out to you before, or at least very briefly and properly. But I've noticed even in my interviews with clients that a lot of the time they don't recall or they don't know if it even happened.
Well, and look at them. Look at the demands. Look at the rights and the way they're expressed to people and the demand. The demand is overly complex. And you see, I've seen some of the interview notes that both of you have taken. The people don't understand what the demand was. They don't understand their rights. Why? Because they're in jargon. And they're written by the government for the benefit of the government. It's like they wrote the charter and said, we're going to uphold these great rights for people in our society. And then they handed it over to the people who were going to apply it. And they said, let's make it as confusing as fucking possible for people.
Exactly. And in a time of vulnerability where you're stressed, you're anxious, you don't know what's going on, and you hear a bunch of legal gibberish.
In the IRP scheme, there is the expectation of perfection for individuals who are challenging their IRP. And there is a very low bar for the police,
Absolutely.
and everybody's confused about their rights. And you've got lay people who've never been in that situation before. Um, and we're IRP, we're talking about immediate roadside prohibitions in British Columbia, but people who've never been in that situation before and don't know how they're supposed to deal with it. And there's all of these things they've been taught, rightly or wrongly, through the course of their life, through observation, that helps them not at all in the end, which is kind of unfortunate. But yeah, good point.
A
What
big
was
thing
That I noticed as well is, especially for new immigrants or people who have English as an additional language, there's also that barrier. So there's jargon for regular people, which is already difficult.
Yeah.
At a layperson. And then you have language barriers. If you're in a jurisdiction where you don't have officers who speak multiple languages, and it's not common for officers to call in a translating officer, then you're also stuck there. And all you can do is agree because it's police. And especially if you're from a country where the police can do much more and have unfettered powers, you're more likely to agree or comply.
You never know what the police are going to do to you. You never know what the police are going to do to you. We have this arrogant idea in Canadian law that the police are always honest and always doing a great job. And, then despite the many circumstances that you've seen, I always think of a Abbotsford police officer years ago walked over the bodies of people who were handcuffed, laying on the ground, used them as stepping stones. Yet the courts still operate under this assumption all the time of giving the police the benefit of the doubt. That's frustrating. But yeah, the language issue is a huge concern. My concern with it often is the translating officers not translating correctly
Or in full.
or in full. So you think about the jargon in an ASD demand. What are they actually telling the person? I'm not there, and we don't have a recording of it. They're still not giving us body cam with any recordings. We have no idea whether or not that translating officer accurately translated that information. Again, jargon that could be so much easier, and maybe they are simplifying it, but maybe they're leaving out important things. One never knows. All right, do we have a third thing, or we're still on to the second one?
We do have a third thing. What do you think is the biggest injustice in driving law?
Boy, I could go on for that one for a long.
Go on forever.
25 years of doing this. Let's hear it.
Oh man.
Big question.
I think it's almost impossible. Kyla, you've given them an impossible question. There's so many things that you see all the time. Maybe we've already covered it because the language barrier and understanding what's taking place, and then having these things that you would otherwise have immunity from used against you.
Absolutely. And I think it's quite an immediate consequence when
Yeah.
you're on the road, and you may be told you have a right to the lawyer, but that's not exercised right in that moment. So I think there's a lot of misunderstanding, whether it's a language barrier or due to being stressed and not knowing what's going on, not understanding the process, and having no one to speak to in that moment is a pretty big injustice, in my opinion.
Yeah. Kyla did a TikTok that covered that a little bit today. It is, I don't want to go into that one further. You can go watch Kyla's TikTok, but I half lost my point halfway through.
Handle people listening and watching at home.
Oh, well,
Or in their car.
she's been going through rights and what you can and can't say at the roadside, and everybody's always saying, well, if you're silent, the police officer's just going to get angry. Anyway, I was just thinking of all of the different sort of injustices that happen. But I will tell you one interesting thing that you probably both have noticed as sort of an overview thing, and that is that so much of driving law meets charter law. And when you start going through charter cases, you discover so many charter cases are driving law cases. And driving law, as I told Kyla over a decade ago, driving law drives the law. And she looked at it and said, you know what, this is a fascinating area of law, and I'm going to dig down into it. Now, she's probably thinking to herself she could make $2 million a year as a corporate litigator. But I persuaded her for good or bad. So we do have one interesting case. Let's move on to, because it's an interesting charter case and it deals really with our issues. And it just came out this week. And strangely, it was heard on June 16th, the judgment delivered June 16th. And we have a transcript already on Canley. And it is His Majesty the Queen and Paul J. Foran. Now, this is an Ontario decision from the Ontario Court of Justice, and it deals with exactly our stuff. Not in the IRP context, but an IRP sort of adjacent thing, because they're using an ASD, and there's a problem with the ASD. So this is, I guess, Justice Kenkel. And the best part about this decision is that it's old school. This decision is like the decisions that were rendered when I was going to provincial court and running lots of impaired driving trials for my first 8 years of practice or 10 years of practice. It's not 26 pages. It's not the judge outlining every witness to this a ridiculous degree. It is the judge zeroing in on the fundamental issues. And what happens here is Mr. Foran is stopped. He's exiting a liquor store. He's got obvious symptoms of impairment, and the police officer makes a lawful demand, lawful ASD demand. Suspicion of impairment. Guy's just been driving. It's within the 3 hours. The police officer's got everything okay there. Makes the demand. He said denies drinking. He denies drinking, as many people do. So many people deny drinking because that's what they've been taught. They've been taught to deny consuming alcohol. Because for years, there was only the suspicion demand. You're sitting there thinking to yourself, if they have no suspicion, I'm not going to be held here for longer than necessary. And people were taught to do it. It's unfortunate. People lie. That lie is inadmissible to hurt your credibility in the criminal context. There's discussion about it here that's only in the ASD context. But the lie is admissible in BC to undermine your credibility, and that's how the superintendent of motor vehicles manages to work backwards retroactively and uphold driving prohibitions. But he says denies drinking, and then he provides a sample into an ASD, and then after providing the sample, he tells the police officer, "Well, I had a drink 5 minutes ago." Now, this is an ongoing concern, right? Because I own a distillery. I'm a owner of a distillery. Kyla is the other part owner of the distillery. And we do tastings in liquor stores. And people come in and they can have a quarter ounce of whatever we're providing. And that is not uncommon. And we do it in private liquor stores. We do it in BC government liquor stores. So people do drink in liquor stores. And you have both seen many occasions where, because you're writing affidavits and assisting in IRP cases, where people are leaving liquor stores. My concern always is anywhere where somebody can have something to drink, if the police do not bring it to their attention, the issue of mouth alcohol, then I feel that you're failing that person, because you're going to test them, especially in the IRP context where you're going to have the punishment right there on the basis of the ASD. But this fellow makes this admission, and then what happens? You both read it. It's 11 pages or 11 paragraphs. It's not a lot to read. What happens is the main investigating officer talks to a qualified technician. It appears to have happened rapidly enough, and comes to the conclusion that maybe now that I've found this out, something is happening in my mind. Do you know what's happening in his mind? He's heard that the guy recently consumed 5 minutes before the ASD test. He's already provided the ASD test and got a fail. What's happening in that police officer's mind?
Well, he knows that the demand is lawful, but now it may be improper. It was a breach of.
So there's a few things. Yeah, I know what you're.
Yeah.
So he makes a breath demand on that basis, or he detains the fellow on that basis, right? But then he finds out that the reasons for his detention are not necessarily grounded. So you're backing up to the reliability of the test. It's not taking a test of somebody when they've had a drink 5 minutes earlier. That is not a suitable candidate for testing, and that is not a sample that was suitable for analysis. So now you no longer have grounds to conclude that that fail was reliable. And in fact, you have the contrary. You have the grounds to conclude that that fail was unreliable. And that police officer was attuned to it, obviously got it, and then talked to a breath test technician who knew a little bit more. and decided, I'm going to take another test, and said, sir, you're going to have to blow again. And after, I guess, 15 minutes would have passed, and again provided a sample and again blew a fail, which was fascinating, because at that point, you get to court, and it was characterized by the counsel for the Mr. Foran that the second test was not pursuant to a second demand. So was it a Section 8 violation? Because there's no second demand. So this is going to be a little lecture now on warrantless searches. So you can nod, but feel free to add something in. So you're not compelled to do a whole lot in this world, and you've got a lot of rights, and the rights are supposed to be protected by the Charter. They're not necessarily always recognized. But, for example, when you're pulled over, you don't have to give your date of birth. You only have to give what is statutorily compelled, because you have a right to silence and you're detained. So it's statutorily compelled if you're driving, not if you're walking down the street, but if you're driving, that you've got to present your license, your insurance, you've got to confirm your name, and you have to confirm your address. Don't have to confirm your date of birth, although police officers often do that, as we all know, because we see it in every IRP report. And that's police going beyond their right, frankly, and they're detaining somebody longer than necessary to ask that question. And it is a concern to me. But anytime you're in that circumstance, you only have to do something if you're compelled by law. An ASD test is what? It's a warrantless search. It is a search without warrant. And in fact, it's a search with a defective standard. So you don't even have reasonable and probable grounds to conclude an offense has been committed. And with respect to a mandatory test, you have no grounds to conclude that anything. You don't even have a suspicion, not even a reasonable suspicion of alcohol in the body. So it is a warrantless search, which would normally be contrary to Section 8. Your reasonable searches and seizures, you're free to be entitled to be free from an unreasonable search and seizure, both unreasonable search, unreasonable seizure, unless it's authorized by law. And so what is authorized by law? Well, ASD demands are authorized by the Criminal Code. They are found to be in violation of Section 10B, but upheld by Section 1 as a reasonable limit. But what happens when you've got an unreliable test after you've made a lawful demand, conducted a test that you thought was lawful, and then found out moments afterwards that it was unlawful? Do you have grounds at that point to make a person blow again when the Criminal Code does not contemplate it? Warrantless search. And so that's how it's framed here. Also, the second test was a breach of the holding off duty of Section 10B, the right to counsel, because he'd already been given his advice about right to counsel, and he hasn't been given his opportunity to talk to counsel. This is fascinating. This is something I've thought about for a long time. And I thought you could thwart the police in some respects by saying no, and then telling them afterward, and it would have to be legit. Yeah, I had something to drink 5 minutes ago, and then deciding what to do. And then seeing if the police officer's smart enough. I mean, this again is, you have a use immunity for those answers in the criminal context. If you have to testify later, it can't be used against you for the purpose of undermining your credibility in the IRP context. Obviously, we all know that. Yeah. So, but interesting. We've never seen this. You've never seen it.
I've never.
I can't think of a case that I've seen it in. You've seen probably 300 IRP cases in the course of your career here, and you probably, Allison, you're probably up to 25 at this point.
At this point,
Yeah. So
almost the same. Yeah. So no.
anyway, so this was an interesting case because the judge had to grapple with this, and the defense lawyer characterized it as a catch-22, and I think there's a good argument for that. The catch-22 that there's no lawful authority to take a second test. In BC, you can volunteer to take a second test if the police officer properly notifies you of your right in the course of an IRP investigation. If they switch gears from the criminal investigation to the IRP investigation, then they can take the second test, but not in that circumstance. So that was a fascinating twist.
Yeah, I think it's interesting because I think the police had every intention to follow the procedure correctly and then was just kind of thrown for a loop when they got the information after making it an invalid test. And you're right, I don't know if the police are prepared for situations like that, or at least all of them, if they understand what to do.
Well, you both read the AlcoSensor FST training manual for British Columbia users probably many times over the course of your career, and this is not contemplated in there. And many things are not contemplated in there. And it's one of those circumstances where you're thinking to yourself, how does an officer deal with this one? Now, I will say parenthetically, I haven't met an officer who has read it. So, despite the fact that the Superintendent of Motor Vehicles publishes it on their website, that is just, it's a deception, really. The police officers get their training. You have no idea what was actually in their training unless you FOI it. And that might be in their training material. When you FOI it, they'll put it together. But otherwise, most officers have not got that. And they haven't thoroughly discussed issues such as this. But there are cases where this has happened. So, and they're interestingly from BC. I think one's called Patchett, where it was a woman who was at the bingo night, and the police officer didn't ask the time of the last drink, and they were in the cruiser driving back to the detachment, and she said she just had one, and he realized that just in the earlier context, I think, was like, I just had it, not I only had it. So that one was that was the end. The reasonable and probable grounds had evaporated, and that detention was then unlawful. And there was another one from Terrace Smithers, Kitimat, where the fellow was outside of his truck, not asked about the time of the last drink. The police officer did the test. He just stepped out of his truck to urinate. Police officer did the test, then found an open beer there, which was the elephant in the room. It was pretty obvious the guy was drinking and driving, and the ASD test was found to be not reliable. And I had one years ago, and this was a good lesson in getting disclosure. We tell people, as you may not know, but you're going to learn here, that we should always dispute their ADP if they're charged with a criminal impaired driving case, because we want to get the ADP disclosure. We may not win in the ADP. We might succeed with the ADP. Every one of them's different, and we've got to look at it and properly advise the person. But we get the disclosure not just for that. We get the disclosure because sometimes there'll be disclosure in there that the police will not give us or will not give Crown Counsel. And so I had one in Smithers where my client provided an ASD sample, got a fail. Driving back to the detachment, the other officer searched the vehicle and found an open beer in the console. Called this officer, and this was in the ADP, called the officer and told him, and the officer did not know what to do, realized that there was probably no RMP grounds, and but continued on, just ignoring it. This case might have allowed him to do that. But the big problem was that the officer did not disclose any of this material in his Crown Counsel report. And so I showed up on the day of the trial and pulled the prosecutor aside and said, here's the material that this police officer didn't disclose to you. It's not in any of the, and the prosecutor was understandably pissed and stayed the charge. I had a good argument there, obviously, the same on the same argument as in that case with the jest had something to drink, same argument in the case with the fellow who had the open beer in his vehicle. Which I think was Judge Krantz, and she was famous in my cases for telling me, one too many questions, Mr. Doroshenko, when I asked something that hurt. And it got back to the office, and people mocked me for it. I still won, but people mocked me for it. But this case is interesting because the judge says, what does the judge say in the Ferran decision? The judge says, you know what, that's fine. There's no demand, but it was still in the procedure of taking the ASD test. The holding off in the 10B part was not a problem. And I'm wondering if either of you have a problem with that.
Well, I feel like it muddies the waters, doesn't it? If you receive new information that contradicts what you're investigating on.
the question is, do you have any lawful authority as a police officer to compel somebody to provide more bodily substance when there's no criminal code authorization to take another test?
No, you just tell them that they have a right to the option, but
Well, that's in BC.
yeah, true.
That's in BC, not in the criminal context. And our BC IRP legislation doesn't apply anywhere else.
Yeah.
I think that this is a problem. I don't know that it's correctly resolved. This is a provincial court decision in Ontario. I like the judge's straightforward talk. I think there is an argument to be made that you could say to the individual in these circumstances, I've now determined on the basis of what you've told me that the sample you provided was not suitable for analysis. I am required to have you provide a sample that is suitable for analysis. And that means that we will have to wait a few minutes and you're going to have to provide another sample. And I actually think that might be the lawful way to do it. But interestingly, the court doesn't go down that route. The court just says it was all during the course of this ASD investigation. But the court goes on to say something that is really quite unusual. So I'm just going to read this part first. At paragraph 4, after his arrest and after right to counsel advice had been provided, Mr. Foran told PC Hyde that he actually had consumed alcohol 5 minutes before the test. Constable Hyde discussed the matter with PC Johnson, who was at the scene and is a qualified breath technician. They agreed that the possibility of mouth alcohol from recent consumption might affect the validity of the initial result. They decided to conduct another test. Constable Hyde administered the second test that also resulted in a fail. Now, my question at that point was, could he have lawfully refused the second test? And I don't know that he could have lawfully refused the second test, but I wrote, could he refuse on there? And then we get to paragraph 10, and it says, I disagree with the defense that the accused's second statement resulted in a legitimate dilemma for the officer. I disagree with the judge on that, but this is just the way it's going to be characterized in law. But the next line is the one that got me. The defense is right that the accused could not have been compelled to participate in the second test. In other words, in those circumstances, you could refuse. This is interesting. It's an interesting twist, huh? That is almost legal advice from the court. I don't know that you could act on it because you can't rely on the court for legal advice. But the suggestion there is that you could really set yourself up for a circumstance where you would be entitled to refuse to provide a test. Anyway, getting to the end, Mr. Foran was convicted. So we're done with our discussion of that. It's time to turn to the ridiculous driver of the week. Now, the ridiculous driver of the week is a good one this week, and I can't look it up on my phone, but I do remember enough about it. It was in Guelph. Police officer sees a fellow on a motorcycle driving very badly, exceeding the speed limit, and he's got a shirt. And on the back of his shirt, it says what, Alice?
Come get me. In
Come
capital letters.
get me in capital letters. So he's on a motorcycle. He's driving terribly. He flees from the police, fails to stop, and he's wearing a hoodie that says, black hoodie with white lettering on the back, come get me. Well, they did. They went and got him, and he's been charged with multiple offenses. What is he charged with?
Let's take a look. Dangerous driving, flight from police. He was fleeing at about 120 kilometers per hour. What else? Stunt driving, highway traffic act charges.
So that was a good one, I think, as a ridiculous driver. Come get me. Don't taunt the police. That'd be my advice. Don't taunt the police if you're on a motorcycle. Radios are faster than your motorcycle.
Even if you can get to 120 kilometers an hour.
Exactly.
Yeah.
Anyway.
Maybe he thought they couldn't see him. He was going too fast.
Maybe.
Was flighty, so,
He's a young guy. He'll have a criminal conviction for dangerous driving that will follow him for the rest of his life. Keep him.
Police, stunt driving.
Sure. So his income loss over the course of his life from that criminal conviction will be what, $10-15 million of lost income for that moment of stupidity. Criminal records are much more stigmatizing now than they ever were. When I started, the internet was barely a thing, right? And none of that information was on the internet, and news stories wouldn't stay on the internet for forever. And so you could live those things down. You might not go into medicine because you'd think that you couldn't go into medicine, or law because you'd think you couldn't go into law. You probably could. But now the stigma of a criminal record is so much more, and it really holds you back. It's unfortunate, but serious, ridiculous driver.
Absolutely.
So I would like to thank you both because this has been a fun experience, and we're going to see if the Buick starts and drive back to the office, and maybe later on this afternoon we'll go for ice cream. So join us next week for another episode of Driving Law with Kyla Lee. Hopefully Kyla Lee will be back. And if you have been driving with a sweatshirt that says "Come catch me" or "Catch me if you can" or any stupid thing like that, and you've been caught, you can give us a call at 604-685-8889. Tune in next week for another exciting episode of Driving Law.
Thanks for joining us, and thanks for all in your viewing.
Yeah.